And I want to welcome you to the Enforcement Committee session of the Medical Board of California. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent, and for board members, please make sure they are off the table so we can avoid feedback noise. Since we have the time constraint, I may speak a little too fast, but stop me if you need to. You may notice board members accessing the laptop during the meeting. They're using laptops solely to access the board meeting materials that are in the electronic format. This is an official business meeting of the Medical Board of California. As such, disruption of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and we'll be asking for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I would ask the person to conduct himself or herself in such a manner that permits the board to transact this business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you'll be recognized. I would like to request all speakers to complete a presenter slip so I can call your name by the appropriate time, and the record of this meeting can be full and complete. However, it is voluntary. Please give the speaker list to Ms. Tu on that side of the table. This meeting will be available via telephone conference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will facilitate the telephone conferencing process. For those members of the public participating via telephone conference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, please press star 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press the pound sign. Please remember to mute the volume on your screen to avoid feedback. Assistance available through the teleconferencing meeting. To request assist, please press star 0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 2, public comments on items not on the agenda, the board has limited the public comment period for individuals on the telephone conference and those present here today to 20 minutes. Therefore, after 20 minutes, no further comment will be accepted. During public comment on any other agenda item, 10 minutes will be allowed to comment from individuals on the teleconference line and those in the audience. After 10 minutes, no further comment will be accepted. Dennis Frankenstein will be assisting with receiving the public comments via the telephone conferencing during this meeting. And I want to remind all speakers to please stay on topic and keep your comment to 3 minutes or less. We plan to end the meeting today at 4 p.m., which is 30 minutes away. We may take some items of order to accommodate the schedule. Unless the end of business, by the way, too. So I would like to call the meeting to order and ask Ms. Tu to please take the roll, call the roll.
Dr. Bolat?
Present.
Dr. Kraus?
Here.
Ms. Yaroslavsky?
Present.
And Dr. Yip?
Present.
Sorry.
Okay. Quorum's present. I would like to remind the members that we'll be taking a roll call also on all the action items. Moving to agenda item number 2, public comments on items not on the agenda. And I don't have any speaker slip on number 2. Do you have any requests on the telephone line?
Amber, do we have any calls on the line?
Yes, we do have someone in the queue now. We'll go to them.
Thank you.
Hello, this is Dr. Gale again. I just was briefly discussing the matter with you in the other part of the meeting, but I just wanted to focus and request you to talk about in future meetings on 1206L foundation models, which are essentially being operated by non-profit hospitals as separate product line or division of a hospital entity, which is something that legislature didn't intend. but some of the hospitals have gone into this forbidden domain, and some of them have even gone to the restricted territory, saying that even the clinics that otherwise meet the requirements of 1206D could be termed as a foundation. While the California legislature intended to create a very limited exemption from the clinic licensure laws for the physicians who practice medicine through a non-profit entity in order to raise funds for medical education and research, the legislature did not intend to provide esoteric pathway for tax-exempt hospitals to attempt to organize and control the large group of physicians in the outpatient setting, and in doing so circumventing the corporate practice of medicine prohibition. I looked at a few patients that were recently abandoned by a large hospital group and some of the affiliated physicians, as one of the competing IPA was about to get the contract for the care for these managed care patients. This is essentially, and this is actually the thing that which worries us most, because this is what you're going to be seeing more and more so with the bundled payment systems that are coming up as a future of the medicines in 2018 onwards. I would want the board to pay some attention to how hospital executives and administrators are trying to push the non-medical agendas to drive medical policies and practices by creating ill relation between the professional ambitions and absence of moral inhibition, and linking the economic imperatives to the professional self-interest. So I would want board to comment on 1206L Foundation in future and the role they have in providing care. Many of the foundations that you see in California are structured that way in various models. They're organized very differently, all of them, but they basically, the end goal they're trying to achieve is the same. So please, if you could get some time and put this on agenda sometime soon. Thank you.
Sure, thanks for the comment, appreciate that. Anyone on the telephone queue? Any other public comment? Speaker? No?
Amber, any other calls on the line?
No other comments at this time.
Thank you.
Okay, great. We'll move to item number 3, approval of minutes from January 29, 2015 meeting.
So moved.
Second.
That's quick. Are there any public comment from those in the audience? From the telephone? Okay, Ms. Tu, please call the roll.
Dr. Bolat? Present. Dr. Kraus?
Aye.
Ms. Yaroslavsky? Aye. And Dr. Yip?
Aye, minutes approved. Now we move on item number 4. Ms. Webber, she already presented herself, will provide a presentation on Utah Center Review.
Thank you, members. As you may recall, the board asked staff to place this topic on the agenda following public comment from former board member Dr. Lowe concerning a UR utilization review interaction that he had had involving one of his cardiac patients. Among other concerning details, the reviewer was not a cardiologist, but deemed a procedure requested by Dr. Lowe to be not medically necessary. And the reviewer did not identify him or herself. So I looked into this and trying to understand how this could possibly be. So I do have some information to present to the members. So the goals of this presentation is we're going to review and discuss a brief overview of utilization review. I will sometimes say UR. And we're going to be discussing UR in workers' compensation context as well as the managed healthcare context. We're going to talk about the board's historical position on UR, the complaint and investigation process relating to UR, which I believe I will be able to streamline and go quickly through, the statutes and regulations impeding investigations relating to UR complaints, and then some suggestions for changes in the law and in outreach. So first, in the workers' comp system, UR, it's used to look at past and current treatment and provider requests for future treatment to determine if the treatment was or is medically necessary. And in workers' comp, the term medically necessary is defined as follows. And in workers' comp, the standard of care is set forth in writing. And it must be based on these standards in the order that they appear. And so first, if it's dealt with by the guidelines adopted by the administrative director pursuant to the section, that has to be followed first. And then there's some other things, if it doesn't fit into the first one, it may fall into peer-reviewed scientific literature, nationally recognized professional standards, expert opinion, generally accepted standards of medical practice, and then finally, treatments that are likely to provide a benefit to a patient for conditions for which the other treatments are not working. And all of this, of course, is required by code sections or regulations. In the managed healthcare system, insurance companies are required to define and disclose their utilization review process, and the criteria used by the plan to authorize or modify or deny healthcare services has to meet certain criteria, including be developed from actively practicing healthcare providers and be consistent with sound clinical principles and processes. So it's sounding like in the law there is this recognition that utilization review involves the practice of medicine, okay? And so now we're going to the board's historical position on UR, and the board in 1998 adopted a resolution declaring that the making of a decision regarding the medical necessity or appropriateness for an individual patient of any treatment or other medical service constitutes the practice of medicine. This was reaffirmed in 2013 at a quarterly board meeting. And this position is consistent with our Business and Professions Code Sections 2038, which defines diagnose or diagnosis, and 2052, which deals with practice without a certificate. And the board is not alone in holding this position that UR is the practice of medicine. For example, the Arizona board took action against a medical director for Blue Cross after a treating physician complained that that director refused to pre-approve a patient's laparoscopic cholecystectomy, finding it was not medically necessary. And the Arizona board's disciplinary action was supported by the Court of Appeal, which found that when a utilization reviewer substitutes his or her medical judgment for the treating physician's to determine that a surgery is not medically necessary, it is a medical decision. This position is also consistent with the American Medical Association's policy regarding the ethical obligations of medical directors. It's also supported by the CMA, and I would like to thank Yvonne Chung and Michelle Rubalcava for meeting with me and putting me in touch with some experts to help me understand some of the issues regarding UR better. So thank you for that. We get complaints from patients whose treatments were delayed or modified or denied, from treating physicians whose recommended treatments were delayed, modified, or denied, and also from representatives of managed care plans whose denials have been overturned by UR reviewers, saying that it was without sound basis. The review of complaints it follows similarly our review of quality of care cases. I am going to move quickly through this part. It goes through the central complaint unit. The patient medical records are obtained from the treating providers, along with any correspondence from the UR reviewer that is accessible. And the UR physician, if known, is provided a summary of the complaint, and a request is made for all the records in his or her possession, and they can write a statement or explanation. And the case is reviewed by a medical consultant. Then if the consultant determines that more investigation is warranted, it's sent to the field. So the board's jurisdiction in UR cases, we need to distinguish between a utilization reviewer's decision regarding medical necessity or treatment from the insurance provider's determination regarding benefits based on that decision. The board's jurisdiction is over the known California licensed physician determining medical necessity, but not over whether the benefits will be paid. So our impediments to the board's role as this oversight and public protection agency is that an expert reviewer does not have to be licensed in California in the workers' comp system. They have to be licensed, but not limited to California. And then once a workers' comp matter is elevated to the independent medical review level, the name of the expert reviewer is required to be kept confidential. And ironically, if a worker does have the ability to appeal a decision, but based on very limited circumstances, such as the final determination was procured by fraud, the medical reviewer was subject to a material conflict of interest, or the final determination was the result of bias, all things that could be very difficult if you don't know who this person is. Under health plans, again, the physician providing the independent medical review does not have to be licensed in California, although California licensed physicians are supposed to be given preference. I'm not sure how that's verified. And again, the independent medical review organization shall keep the name of the reviewing physician confidential, except under very limited circumstances. But this is something that's very important for medical directors to know, and that is that the medical director in the workers' comp system is required to be licensed in California, and the same is true under health plans, so I will move quickly through these slides. But it's important to point out some of the phrases that I don't know is obvious to medical directors in this position, that they shall ensure that the process by which the employer or other entity reviews and approves, modifies, delays, or denies requests complies with the requirements of this section. And then it says, nothing in this section shall be construed as restricting the existing authority of the Medical Board of California. And then, again, in regulations, the medical director is responsible for all decisions made in the utilization review process. Similarly, in health plans, medical director has to hold an unrestricted license. They're responsible for ensuring that decisions comply with the law, and part of that law says it shall be consistent with clinical principles and processes. Again, a medical decision-making flavor there. So I do have some suggestions for change, because I think that there needs to be some reconciliation in the law. These are not, the labor code and the health and safety code are, the board doesn't have a whole lot of influence over that. But there needs to be some reconciliation, and I would like to see the board support legislative changes to require that the physician be licensed in California, have a similar board certification as the treating physician who they are opining about their recommendations, and identify themselves in their reports. We all have to take responsibility for what we say and do, and the impact that it has on people. And then finally, supporting outreach efforts to educate medical directors about the board's oversight in the utilization review process, because I have it on good authority that that message may not be out there very well, and they are responsible for a lot of decisions flowing through. So with that, I'll take questions.
Dr. Kraus?
Thank you, Ms. Webb. This is very illuminating. It's an apparent contradiction that utilization review is defined as the practice of medicine, and yet utilization reviewers can effectively practice medicine in California without a California license. So I agree with your suggestions for legislation. I'm interested to know if you have statistics on how many complaints over the last few years the medical board has received regarding utilization review, and what those findings have been, and how many of those complaints could not be adequately investigated because of reviewers who were not licensed in California.
I know that Ms. Ramona Carrasco did a presentation, I believe last October, and she had some numbers. I unfortunately don't remember them. It's a very small number of complaints. As far as I know, it has not progressed through disciplinary action, and there are a number of them that cannot move forward because we don't know who the reviewing physician is, or they're out of California.
Thank you.
I want to thank you for this detailed report. I've made comments on several of your slides and would like an opportunity at a later date to just ask you questions without taking up the time here, but to absolutely volunteer or try and figure out a way that we can do better outreach to those entities that need to know about this. I mean, this is really important, as well as doctors need to know. I just think this is, hopefully it takes the place of a newsletter article. Excellent. Thank you.
We have two requests to speak from the public. Ms. Genevieve.
Good afternoon, Genevieve Clavrol. I'm totally appalled of the workers' comp system. Most of the doctors, I would say 99% of the doctors who review any kind of chart are all emergency physicians. They are the less likely to be competent to care of long care treatment. Because all they do is today is a trauma. That's all they are. That's not they are bad doctors, but they are not. About complaint, 4 out of 5 reviews are denied by the reviewing system. So either all the doctors who take care of workman's comp are incompetent, or the system is really rigged. And I think that the system will really need to be looked in detail. I think it's scandalous. And like I said, either all the physicians who take care of workman's comp are incompetent, or is something wrong in the system. The physician who do the review, 99% of the time, they are not qualified. 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 They are not is to Maximus, who has a sole vendor contract in the first place, which is totally inappropriate. And I think some inquiry really needs to be done to see how this system is being dealt with. And I have really followed that very closely, and I think that something needs to be done, and I'm glad to see you looking at it, because that's, like I said, ER physicians are fantastic for the ER now. They are totally incompetent for long-term treatment. And every review I have seen, and I have seen a lot because I've been looking at it carefully, including the one over my case, are all ER physicians.
Thank you. We have Ms. Yuan Chong from CMA.
Yvonne Chung with the California Medical Association. We really appreciate the board's attention to what we feel is an underenforced area in the practice of medicine. And we agree with Ms. Webb's recommendations that more transparency is needed with regard to the physicians who are actually conducting the reviews, and that medical directors should be made aware that the medical board can't take action against them. A suggestion for a model for how you might be able to get more information about the physicians that are performing utilization review. The Department of Consumer Affairs has a registration system for telephone medical advice services. So if you're Kaiser or any sort of health plan, you have an advice line, you have to register, and the plan has to provide a list of all the providers who will be providing that service, whether they are in state or out of state, and whether they are licensed. So that might be a way, sort of kind of along the lines of what you do for fictitious name permits, to really get at the entities that are providing the service, because I think that's really the issue here. It's not necessarily the individual physician. And this would also help you determine, in terms of the reviewers, whether or not appropriate supervision is being provided, because in many of these cases, the initial review is actually not done by a physician. It may be done by a nurse practitioner or some other health professional, and that will help you to figure out what the chain of review actually has been and help in your investigations. Thank you.
Thanks, I appreciate it. Any comments from the telephone?
We do have somebody in the queue. We'll go to them now.
Thank you, Ms. Webb, for such a wonderful presentation. My name is Kanwar Gill. I'm calling from Fresno, California. I sent you an email in regards to this metro last night, but I want to tell you that unless the UR people are asked to get a California license, there is really nothing much I see happening on this arena. I'll give you an example. I had a patient, a state worker, a state of California employee, where a UR was done apparently by a Texas physician. And that physician, we found out later on, was not even part of a UR. It was done as part of an internal audit for a company owned by a bigger insurance company. And subsequently, I had to contest with the medical director, a California licensed physician, to get a surgery for my patient. And the issue they were bringing up was causation and compensability of the claim, which has nothing to do with the medical necessity. So anyway, long story short, the way we resolved the issue was I asked the patient to file a complaint against me personally so that I can explain it to the board. The complaint was never filed, the surgery was done, patient was happy. But what I'm trying to say is there is a layer of UR being done by unlicensed people. There is a layer of UR being done by individuals who are not part of UROs. And those kind of a complaint falls under the purview of medical board when that kind of an action results in an interfering of the medicine practice of a California physician. So if a reviewer from outside, working outside of the URO, makes a determination that impedes the practice of medicine in California, board is entitled to take an action, and I would want to see in those cases board to take action. I sent you an email. It has a detailed explanation of what was going on for 2.5 years, part of a state fund program involving 3 major workers' comp group, Kaiser, US HealthWorks, and Concentra. And the scheme of things was basically denying and impeding the decision stream and reach the desk of a UR reviewer. And a lot of time, patients were being affected. In fact, there was a significant cost saving that was told to me occurred as part of this illegal UR thing that was going on. Out-of-state physicians were doing it, and no action seems to have taken to date against the medical directors. So I would want you to make a legislation effort towards getting every UR reviewer to have a California license. At least you guys can go ahead and take some action against those people if they do things which are inconsistent with the Medical Practice Act. Thank you.
Okay, thanks, appreciate it. Dr. Krause?
I'd like to move that the Enforcement Committee recommend to the full board, in accordance with Ms. Webb's presentation, that we support legislative changes to require utilization review and independent medical review physicians be licensed in California, be actively practicing, have similar board certification and/or training as the treating physician, and identify themselves in their reports, just as Ms. Webb suggested.
Let's second that.
And I do want to make it clear that this isn't legislation that we would sponsor, but there are efforts periodically to do this, and so the board would take a support position on bills like that.
Yeah, I think it's important our staff have conversation with the Department of Managed Care or the California HMO Association, looking at the qualification of the medical directors, so that we can have a better idea. So we have a motion second floor. Ms. Chu, call roll, please.
Dr. Bolot? Aye. Dr. Krause?
Aye.
Ms. Yaroslavsky?
Aye.
And Dr. Yip?
Aye. Recommendation approved. So move to item number 5, Ms. Robinson. We provide an update on the demographic study.
Good afternoon, Chair and members. You may recall that I presented information to this committee on ethnic background data for complaints, investigations, and discipline at the October 23rd meeting. I also presented data from fiscal year 10-11, 11-12, and 12-13. The data, I also gave data from fiscal year 12-13 with regard to the type of discipline that was imposed. At this meeting, you directed staff to research potential third-party organizations that could analyze the data and complete a more in-depth review. In January, board staff met with the California Research Bureau, as I will now refer to as the CRB, and followed up with a meeting with interested parties to discuss the disciplinary action demographics. At the January 29th meeting, this committee approved the board to enter into a Memorandum of Understanding, or MOU, with the CRB. In July, board staff met with the CRB to solicit input on the MOU, which was executed on July 29th. In early August, board staff met with the CRB to discuss the data needed to conduct the study. Board staff provided the data to CRB on August 26th and 27th. That included disciplinary action records from fiscal year 2003, 2004 through 2012, 2013. On October 1st, I checked in with the CRB to see how the study was progressing and to get an estimated timeline for completion of the study. The Bureau informed me that they were in the process of conducting a thorough review of the data we had provided them. And once completed, the CRB will develop a research plan, outline a work schedule, and then begin conducting interviews with outside stakeholders. This Monday, the CRB requested additional information on the physician survey data that our IT staff is working on providing to them. So the study is moving forward. I will continue to monitor the CRB's progress and look forward to giving further updates. This concludes my update on the demographic study. Are there any questions?
Any questions for the member, Dr. Krause?
Thank you for following up on this.
You're welcome.
I also recall at one of those meetings that my input was offered. And yet I've not had contact from them. So if you could remind them, particularly at this stage where they're designing their study, to be in touch with me, I'd like to work with them.
Most definitely. As soon as they review the data, they're going to reach out to the outside stakeholders, which includes you.
Thank you.
And Dr.
Absolutely.
Kraus, that is specifically in the MOU.
Yeah.
Thank you.
Can I suggest that we have another update at our next committee meeting, please?
Oh, absolutely.
Thank you.
Absolutely.
Excellent. Thank you
Thank
for
you.
following through and following up on this. Thank you.
No problem.
I don't have requests to speak from the audience. Anyone from the telephone?
No one on the phones at this time.
Okay, great. We'll move to item number 6. Our new chief, Ms. Depp. Enforcement program update.
Thank you, Dr. Yip and committee members. To provide a quick staffing update, Enforcement Program Management continues to fill vacant positions within the various units of the Enforcement Division. In the July 2015 Enforcement Summary, it was reported that the Central Complaint Unit had 5 vacancies. 4 of those vacancies have been filled and the new employees have begun working. Regarding the 5th vacant position, the top candidate is progressing through the hiring process and we expect the candidate to begin employment shortly. The Central Investigation Office filled its remaining Special Investigator non-sworn position, and the new employee is scheduled to report to work on November 2nd. In the Probation Unit, the Northern California Inspector 1 position was filled, and the employee reported to work in September. Interviews have been completed to fill 1 Inspector 1 position in the LA metro area and 1 Associate Governmental Program Analyst in Northern California. The Discipline Coordination Unit is fully staffed. Presently, in the Central Complaint Unit, the number of days it takes to initiate a complaint has increased to an average of 15 days. However, staff continues to work together to reduce this time frame to 10 days to ensure compliance with Business and Professions Code Section 129. Additionally, analysts are continuing their efforts to reduce the number of days needed to complete the processing of complaints. This has been a difficult goal to achieve due to the vacancies in the Central Complaint Unit, but the recently hired staff are making significant strides in learning their new functions. Management is confident they will contribute greatly once they have completed their training. Furthermore, the management team in the Central Complaint Unit has recently started conducting case reviews with staff as a way to monitor the workload and provide a forum to assist the analysts with moving through the complaint handling activity by providing timely direction in processing complex complaints. Lastly, effective August 31st, 2015, the board received authority to once again issue citations containing orders of abatement and fines to licensed physicians for violating the statutes mentioned in California Code of Regulations, Section 1364.11. The special investigators in CIO are each currently carrying a caseload of approximately 35 to 40 cases. However, this will decrease with the addition of the new staff person that will start working in November. Since the last summary report of July 2015, the unit has closed 58 cases and has transmitted 6 cases to the Attorney General's office. 3 were for convictions, and 2 were petitions for reinstatement, and 1 was a medical malpractice case. Staff in the Discipline Coordination Unit continues to focus their efforts on restoring public disciplinary documents to the board's website to ensure compliance with Assembly Bill 1886. Staff has been offered overtime to finish the project, and management has devised a daily schedule for all staff to work on this project with the hopes of completing it by December 31st, 2015. Board staff will also be looking to hire temporary help to finalize this project. In the probation units, inspectors in each office are beginning to see orders that include the new disciplinary guideline language contained in the recently implemented uniform standards for substance abusing licensees, which took effect July 1 of 2015. On November 4, 2015, the inspectors, supervisors, and management will meet to discuss and develop a comprehensive training plan for the unit's inspectors, focusing on subjects that will enhance their skills in monitoring probationers. In addition, I've been looking at reviewing the probation operations manual, conducting case reviews, and taking a look at current policies and procedures to ensure where improvements can be made in this enforcement program. An issue has been raised by the Office of the Attorney General regarding use of the same investigator that works a complaint both criminally and administratively. The Attorney General's office is asking for the Division of Investigation to develop a parallel policy for these types of investigations. During the month of November, the medical board will reach out to HQIU and the Attorney General's office to address this concern of conducting parallel investigations with the goal of reaching an agreement that works best for all agencies. In addition, a process needs to be established with HQIU where the board is able to monitor the complaints deemed to be criminal investigations. This oversight will ensure these complaints are being processed in a timely manner to include the filing of an of an interim suspension order or an accusation if the criminal investigation is not advancing. I have begun to have these discussions with their new deputy chief. Regarding vertical enforcement legislative report, on October 7, 2015, staff and I met with Deputy Director Michael Gomez, Senior Supervising Deputy Attorney General Gloria Castro, and Supervising Attorney General Terry Jones, and retired DCA Attorney Anita Scurry to discuss the highlights and challenges of the vertical enforcement process. Ms. Scurry will be assisting the medical board staff in writing the mandated report that is due to the legislature in March of 2016. The report will communicate the effectiveness of the process in areas needing improvement to enhance the usefulness of vertical enforcement in investigating medical board complaints. The intent is to have 2 board members work with staff once the report is drafted to review and provide feedback regarding the content. A draft report is expected to be completed at the beginning of January 2016. We hope to be able to provide a draft to the board members at the January board meeting for approval. However, it is dependent upon the ability to run the necessary reports to be able to complete the draft. If necessary, we may need to hold a special meeting for the review of the report in February. The development of a cloud to share case information electronically via a secured system has also been developed and would be utilized by staff within the Enforcement's Disciplinary Coordination Unit, CIO, probation units, HQIU, and the Attorney General's Office. This system will permit the timely receipt of case information and reduces operating costs for the 3 agencies. A meeting is scheduled on November 3rd with the Attorney General's Office and HQIU to discuss the implementation of this process. That ends my enforcement update. Are there any questions?
Can I just ask you a question about, you mentioned that currently investigators have 35 to 40 cases each. How does that compare to last year at the same time?
I know that they just started in July of 2014, and I'm not sure.
Approximately, I mean, is it up, is it down,
It is up because we lost, this is our non-special investigator, so these are the ones that are still with the medical board.
Right.
So they probably had, I'm gonna look, probably about 20, about 25. Okay, so they had about 5, but they have about 5 more dispersed amongst them, taking care of the one workload of the one analyst or the one investigator that's gone. So it's up by about 5.
It's not that bad yet.
No. In fact, it's going to go down because as soon as that one gets
down yet.
Yep.
Okay.
Yeah.
Thank you.
Any questions from members? No? Great. We have one request from the audience. Forgive me, I pronounced it wrong. Ms. Marian Hornsworth. The next one? Okay. Okay. You mean for the football? Oh, okay. Anyone from the telephone?
Amber, any calls on the line?
No questions on the phone at this time.
Okay, great. Now, we'll move on to item 7. Our director, Ms. Kurt Meyer, and Ms. Delp, on the meeting with the Office of Administrative Hearings.
Good afternoon. On October 16th, Ms. Delp and I met with Zachary Marazzini, the new director of the Office of Administrative Hearings, and Deputy Director Melissa Crowell, and Presiding Administrative Law Judge Alan Alvord. The meeting was a meet and greet as well as an opportunity to update them on the happenings of the board. We spent a significant amount of time talking about the board's new regulations pertaining to the uniform standards for substance abuse licensees. We discussed how the language in each condition should not be amended pursuant to the regulations. We also discussed the length of time for setting hearings. Lastly, we talked about the required training for the administrative law judges. And as most of you know, this is actually one of our items that's in our strategic plan. And with the absence of an enforcement chief, we haven't really been able to do that. And so I'm happy to report we actually have a very robust training that we're set up now with OAH. And I'm going to have Ms. Delp talk about that.
So beginning next month, I'll be working with Judge Alvord from OAH to schedule training with the administrative law judges. Due to the limited availability of the judges' schedules, training will be held on the last Friday of a month or during a lunchtime period. Some of the training topics will be, but are not limited to, training on impairment and how it impacts the practice of medicine, medical record-keeping standards and expectations, emergency room procedures, prescribing practices and expectations, review of systems of the body, treating comorbid patients, medical terminology and medical error, fitness for duty evaluation for physicians alleged to have mental illness, physical disabilities, and or substance abuse laws. The Office of Administrative Hearing is very receptive to receiving the training, and we look forward to the opportunity to provide this continuing training on an ongoing basis.
And I just want to add that in a lot of times when we try to set up this training, we have problems sometimes finding individuals that can provide this training to OAH, so we may be reaching out to you members to try to identify a speaker that can come in. I know in the past we used to reach out to UCD to come in, and we've reached out to PACE, but I think it'd be good if you all have individuals that we could reach out to provide that training. That would be helpful as well, some of your colleagues.
Are those training going to be in different sites like Sacramento, San Francisco?
The great thing about OAH is they can teleconference, a video conference throughout their state. So that's how they've put all of them on. In fact, they've had training in San Diego that's gone statewide, as well as in Sacramento that's gone statewide, and that's how they do their trainings.
The topics that you've given us, which are excellent, are they also included from conversations that we've had in the panel meetings as to where the weaknesses are?
Yeah, I think we've taken a lot of that into consideration. We've taken it from three things we've heard from board members and panels. We've also taken it from the Attorney General's office when we've been meeting with them, as well as then OAH themselves came up with a lot of the areas where they feel that it would be helpful for them.
Thank you.
Any question from members? I don't see a request from public. Any question from telephone audience?
There are no questions in the queue at this time from the phones.
No? Okay. We'll move to item number 8. We step again on the expert review training.
Staff is reviewing and updating the expert reviewer guidelines in preparation of the upcoming expert reviewing training class. We're aiming to conduct the training in March of 2016 in Southern California. I've reached out to the previous presenters to determine their interest in being a presenter again, and I'm in the process of securing a location for the training and continuing education credits for taking the class. In addition to setting up the training, a recruitment plan to expand the number of experts with specific specialty fields of medicine has been developed. The plan includes inserting an article in the board's newsletter that stresses the purpose and importance of utilizing experts, a revision of the board's recruitment letter to encourage participation into the program, creating a brochure to accompany the recruitment letter that will highlight the benefits, expectations, and compensation for services regarding the program. In addition, we're looking into the possibility of taking some testimonial videos of existing experts that can be added to the board's expert reviewer webpage, so prospective experts can hear firsthand about those currently that participate in the program. As well, we will be reaching out to physician groups and physician organizations to do a presentation on the expert reviewer program. The specific fields of medicine where our recruitment efforts will focus are stated in the Utilization Quarterly Expert Report, which is included in your board packet found under agenda item number 8 of the full board meeting. Lastly, regarding the expert reviewer program, the expert reviewer database called MEDEX is expected to get a new overhaul. Program staff will be recording elements needed to enhance the antiquated database and will be working with staff from the Information Systems Branch to make the system user-friendly for staff, investigators, and medical consultants to search for qualified experts to assist with complaint investigations. That concludes my update. Are there any questions?
Question from members? I don't see a slip on public. Any question from the telephone audience?
No questions from the phones.
Okay, great. We move on to item number 9.
Okay.
For the psychotropic medication being prescribed to children in foster care.
The board will be meeting with another pediatric psychiatrist to determine if interested in reviewing the data the board received from the Departments of Healthcare Services and Social Services. It has been challenging to find an expert that is able to opine regarding the data that has been provided, as the data appears to lack substance to make a determination as to whether there is inappropriate prescribing of psychotropic medications to children in foster care. The board will meet with the potential consultant on November 9th. The physician currently works for the UC Davis healthcare system and specializes in child and adolescent psychiatry, forensic psychiatry, and psychiatry. The board is hopeful that this physician will be interested in working with the board as a medical consultant to opine regarding the pending issue. On October 12th, Executive Director Kirchmeier, Chief of Legislation Jennifer Smoes, and I met with executives from the Departments of Healthcare and Social Services to give them an update regarding the board's analysis of the data they provided per the data use agreement. The board explained that the data may not be sufficient to make a decision as to appropriate prescribing and that the board is still seeking a physician. In addition, we explained that we may need to obtain additional information, and our plan is that the medical consultant will identify what additional information is needed in order to make a determination. However, on a positive note, the agencies and the board developed a notification process whereby individuals in the healthcare delivery system for foster care children can directly contact me or Enforcement Program Manager Paulette Romero if they believe a physician is inappropriately prescribing medication to children in foster care. In turn, Ms. Romero, Iowa, contacted the Department of Social Services to obtain all de-identified patient information for the foster child for that prescriber. The de-identified patient information will be sent to the board's medical consultant, who will opine on what patients the board will need to obtain patient records, if any. Board staff will then work with Department of Social Services to obtain the patient records through a court order so the board can proceed with an investigation. That concludes this update. Are there any questions?
Comments from the board? Any from the audience? From telephones, audience?
Any calls on the phone, Amber?
No questions on the phone.
Thanks, Ms. Deb, for your report and effort. You pick up so fast in a short period. I'm sure with help from our director. So, for future agenda items, any members have any suggestion, comment for the next Enforcement Committee meetings? Any public comment from the audience? From the telephone?
None at this time.
So we'll move on to adjourn the meeting and stay for the full board meeting.
Which is where?
Which is here, right?
So moved.
So Mr.
Moved, I've done, absolutely.
All right, great. Thank you.